Good morning. I'm Arbitrator Swift. What I'm going to do today with this pre-arb is I'd like to discuss how we'll conduct the arbitration hearing next month.
Would you first introduce yourselves to me?
I am the Director of Human Resources, and my name is Sarah.
I am the attorney representing Pat, and my name is Mary.
Thank you very much.
I have before me a copy of your evidence book that the two of you have put together. And I'd like to go through the evidence book and your witness list so there are no surprises when we have the hearing next month, okay? So I'm going to assume that you've agreed on this evidence. But if that's not true as I go through the evidence book, if you could let me know, I'd appreciate it.
Are you ready to go forward?
Yes.
Yes.
The first thing that I see is the employee handbook, the arbitration clause, and that's Joint 1. Joint 2 is the employee handbook clause that states the employee is an at-will employee. Joint 3 is the employee contract, which states Pat is an at-will employee, but he has the right to arbitration for,
And I quote from the book, any dispute involving his employment.
Joint 4 is the employee handbook clause that prohibits discrimination in the workplace. Joint 5 are the rules and regulations of the American Arbitration Association for arbitration hearings. I'm going to stop here and ask you, do you both agree that all of these exhibits from Joint 1 through 5 should be in the exhibit book?
Yes.
Yes.
Thank you. Joint 6 are the employment rules. Joint 7 is the letter of discharge. Joint 8 is the employee request for arbitration. Joint 9 is Pat's most recent evaluation for the past 6 months. Joint 10 are pictures of a smashed computer on the sidewalk. Am I correct in assuming that all of this will be in your evidence book for arbitration?
Yes.
Yes.
Thank you. Now the last two exhibits aren't joint exhibits. The first is the employer's exhibit number 1, which is an arbitration award by Green number 5. And I see that I can find that at the Grand Valley State University website. And employee number 1 is an arbitration award, Jones number 9, and I can see that one at the Grand Valley State website as well. Is that correct?
Yes.
Good. In regard to the hearing, I typically have the employer go first with discharge cases, even if the employee is at will. I also typically allow new exhibits and additional witnesses to be added to the witness list anytime prior to the hearing, as long as the other side is notified in writing in a timely fashion. I assume you will both agree to this.
Do you allow witnesses to come via video conference if they cannot be at the hearing?
Of course. As long as everyone can ask questions of the witnesses, it's in real time, and they can all see and hear the witness. Okay?
Anything else?
No.
Not at this time.
Okay, thank you. If there are no other questions, I will close the pre-arbitration. And I thank you for today for meeting with me via Uvu. Thank you.